So, Danny, we've got some news just now from reporters inside the courtroom in New York. Judge saying, at this point, I can inform you that we're moving ahead. Jury selection on March 25th. So this trial is on track for March. Trump's attorney called it an injustice. We heard from Donald Trump before he went to the courthouse suggesting that his team would try to delay this if indeed it was scheduled for March. So what are some of their options? Do you think they are going to be able to push this case beyond that March 25th date?
Well, first, that March 25th date may be a firm date in the court's mind, but all I can say is this. Things happen. We've seen that already so far in just the last year. Unexpected motions, for example, in Fulton County can delay a case unexpectedly. So even if all the parties think that is the date trial's going forward, something may come up. What that also implies, based on what you're telling me, is it seems very probable that the motion to dismiss is going to be denied. No surprise there. This is the kind of motion that a trial court will always deny. But the defendant is really not making it for the trial court because judges hate to take cases away from prosecutors. Instead, now the record has been made, and some of these creative theories of dismissing the case by the defense will eventually go up on appeal if there is a conviction. Whether or not they'll survive on appeal or have a shot at appeal, I mean, the selective prosecution, that one's always a loser. The pre-indictment delay, that's the argument that, hey, the prosecution had these facts and they sat on them so long that it prejudiced the defendant because we as defense counsel can't track down witnesses. They have died. They've moved away. That's a legitimate argument. I've tried it in cases where the prosecution sat on a case for decades. It has never worked, even to my knowledge. And I did some research on it some time ago. Very rare for pre-indictment delay to result in throwing the case out. But you preserve that record for appeal, and maybe you have a shot if you get convicted once you go up to the appellate division.
We're going to go to the Georgia hearing in 1 minute, but first, Dave Ehrenberg, you are a prosecutor, and right now you're looking at a split screen, one in New York and one in Georgia. I'm curious, what are your thoughts today? What are you looking for today?
Well, Joe, I think it's important that the New York trial moves ahead. I think that's an important revelation we just had, that this thing is going forward, because there are only two cases that have a chance to go to trial before the election. That's this one and the one in Washington, D.C. Over election interference. And although it is the one in New York, the fourth out of four cases when it comes to the strength of the case, it doesn't mean it's a weak case. I agree with Chuck on this one. But it is not an easy case for prosecutors because it's only a misdemeanor to falsify business records. It rises to a felony once the misdemeanor is used to conceal another crime. So what is that other crime? The indictment doesn't say, but Alvin Bragg, my counterpart up there, has insinuated it's a federal election crime. It's election interference that Trump tried to accomplish. Then the question is, can a state bootstrap on a federal law of federal campaign finance violations? Remember, Trump was running for president, not a state office. So this is uncharted territory. And the key detail for me, though, that was in the statement of facts, is that Trump apparently directed Michael Cohen to delay paying Stormy Daniels until after the election because he wanted to avoid paying it altogether, because then it wouldn't matter whether she went public. So that shows his intent to interfere with the election. And a quick thing on Georgia, the stakes are raised in Georgia because Fani Willis and Nathan Wade said, and Nathan Wade said this under oath, that their relationship started after he came aboard as special prosecutor. If the defense can prove otherwise, then it shows a lie to the court. It shows that they misled the court. And I think Nathan Wade will be bounced, and very likely Fani Willis as well.